Not every DUI in California leads to jail time, but some do, and the difference comes down to a few key factors. In this video, I'll break down what puts you at risk and how those outcomes can change. Hi, I'm Nano Knight, and I've spent over 16 years in a courtroom, first as a prosecutor and now as a California State Bar board-certified criminal law specialist. If you need to speak with a defense attorney for an urgent matter, give Knight Law a call at 408-877-6177. Let me give you the answer you're looking for right up front. A DUI arrest in California does not automatically mean you're going to go to jail. For many people, especially first-time offenders, incarceration is not the end result. It's pretty drastic and really rare. But whether you avoid it and how you avoid it really comes down entirely to the specific facts of your case and how strategically your defense is handled from the very beginning in existence of any aggravators in the facts of your case. So let's start with what the court actually weighs when deciding the outcome. The single most important factor is whether this is your first offense. First-time DUI defendants with no aggravating circumstances, for example, no injuries, no accident, no extremely elevated blood alcohol level, are the strongest candidates for alternatives to incarceration. California courts have real discretion in these cases, and a skilled defense attorney knows exactly how to use that discretion to your advantage. Your blood alcohol concentration at the time of the arrest matters significantly. We call this the BAC. A BAC just over the legal limit of 0.08 is treated very differently from a reading of 0.15 or higher. The higher that number, the more aggressively the prosecution pushes and the fewer alternatives the court is willing to consider without a strong defense already in place. Whether anyone was injured during the incident is another critical factor. A DUI that resulted in a collision, bodily harm to someone, or property damage moves into an entirely different legal category with far more serious consequences. And if you have a prior DUI conviction within the last 10 years, the court's flexibility shrinks considerably with each one on your record. Now let's talk about what actually happens instead of jail, because for many DUI defendants, there are legitimate court-approved alternatives that allow you to keep your job and your daily life intact. The most common outcome for first-time offenders is probation. Rather than serving time behind the bars, the court places you on a supervised probation period, typically running 3 to 5 years. You're expected to complete a state-licensed DUI education program. For first offenders, is typically 3 months. Pay all court-ordered fines, stay out of further legal trouble, do not commit any new law violations, and remain in full compliance for the duration, comply with all the court-ordered terms and conditions. When probation is completed successfully, jail is completely off the table. DUI education programs are almost always mandatory, regardless of your specific sentence. But here's something smart defendants do that most people don't think of. They enroll in a program before their court date, not after. Showing up to court having already taken that step tells the judge you are taking responsibility. You're being proactive instead of reactive. It signals accountability, that you understand the need for rehabilitation. You've taken concrete steps towards realizing that. And I've seen that kind of proactive decision shift how a case resolves in a pretty meaningful way. Community service is another option the court can authorize instead of a cell, where you fulfill a court-ordered number of hours contributing to public service, some work at a nonprofit or sheriff's alternative work program, and you can do this while you maintain your employment and your regular life. Home detention with electronic monitoring is also available in certain cases. You wear an ankle monitor, remain within approved boundaries, and check in as required. It carries restrictions, but it is not jail, and for someone whose career or family situation makes incarceration catastrophic, which for many people it is, this is a very significant distinction and could be a really good option. The court may also require an ignition interlock device as part of your sentence, which is a breathalyzer device that's installed on your vehicle that must be passed before the engine will start. Courts generally respond well to defendants who comply with this requirement because it demonstrates a genuine commitment to not repeating the offense. Now, let me be direct about what makes jail significantly more likely, because you need this information clearly. Repeat offenses change everything. A second DUI within 10 years is treated far more seriously. A fourth DUI is a felony charge in California. If prior convictions exist on your record, alternatives to incarceration become harder to secure and require an aggressive legal strategy to pursue successfully. Aggravating circumstances also shift the entire equation. A minor in a vehicle, a child that's in the back seat at the time of your arrest, or excessive speed, creating unsafe conditions for other travelers, or refusal to submit to chemical testing or a BAC that's significantly above the legal limit, all increase prosecution pressure and reduce the court's flexibility or discretion in sentencing. There's one more thing most people don't realize when they're arrested for a DUI, and it is critically time sensitive. Your arrest triggers two completely separate proceedings: your criminal case and a separate DMV process, which is a DMV administrative hearing that's designed to determine whether your license gets suspended. These run independently of each other, even though they stem from the same DUI arrest, and they have different rules and different deadlines. You have exactly 10 days from the date of your arrest to request your DMV hearing. If you miss that window, your license is automatically suspended. An experienced DUI attorney handles both at the same time, because losing your license affects your ability to work, to comply with every court requirement, and to hold your life together while this case is pending, while you're building your defense. The bottom line is this: the window to influence your outcome is open right now, and it does not stay that way. Evidence gets stale. Deadlines pass. Every day without experienced legal counsel working on your case is a day your options continue to narrow. Act now, not after your first court date. And if you've been arrested for a DUI in California and you're sitting at home worried about your license and what's going to happen, call NightLaw at 408-877-6177. Let's talk about your case, your timelines, what your options are, what we can do right now to protect your record, your driving privileges, and your future. And if you want to know more legal tips, watch this next video.